Good afternoon, Council. Thank you for your patience with us today. Just because you're last does not mean you are least. We are still functioning in our roles here today. Let me ask you this individually. I want to make sure I try to get everyone's surname right. So would it be Nieberger?
Nyberger.
Nye. And for Appellate Council, is it Sebago or does Sebago with the E?
Sebago.
Sebago, make the long A. Okay, got it. Thank you so much. I'm sure you can guess why I asked these questions about pronunciation. And we are ready. Counsel for the plaintiff, for the appellant, let me ask you, Ms. Nyberger, do you want to reserve time for rebuttal?
Yes, Judge, 3 minutes, please.
Okay, I will do my best to discreetly interrupt you at that moment. And with that being said, we are ready to go.
Thank you. May it please the court, Ellie Nyberger for the appellants, the City of Largo and Nathaniel Hansman. This is an appeal from a non-final order granting the appellees, who were the plaintiffs below, a motion to reopen the case and vacating a final order of dismissal that was entered months earlier. The final order of dismissal dismissed the case without prejudice based on failure to timely effect service of process within 120 days. The facts are, this was one of the many tort cases that was filed back in March of 2023, in the days before the tort reform legislation took effect. The case was filed and 7 months passed with no activity until in October, the court entered a notice of intent to dismiss the case for failure to effect service. On that date, the plaintiffs filed a amended complaint as a matter of right, as a matter of course, against both the same defendants. I made some minor changes to the allegations, and also at that time, for the first time, requested that summons be issued. The plaintiffs also sent the judge a letter informing the judge that they had filed an amended complaint, requested and received issued summons, and expected to be able to serve the defendants in the near future. The notice that the plaintiffs were given stated that the case.
We have a frozen video, if anyone is listening in.
Judge Castleman, it looks like it's on the attorney side.
Okay, thank you, Rita. Are you back, counsel?
I'm here. Yes, can you?
Okay, you froze for a moment.
Oh, okay.
Or we're aware of that, so I was wondering what happened. They said it appeared to be on your end.
Oh, I'm sorry. Okay, I did
Right.
I did not realize. So
there's no way of telling you that unless you can hear.
Sorry about that. So just picking up with the notice of intent to dismiss, it stated that that the case would be dismissed without any further notice.
You know, there's an interesting thing about that document. If you look at it, it was not sent to the plaintiff. It was sent to the defendant. The record, page 15, is that correct? It was sent to the defendant.
I'm sorry, the defendant, neither defendant had appeared in the case. I believe that it had been mailed.
I was just looking at the top of it on the record, page 15, and it doesn't have to the plaintiff. It has to and the name of the defendant.
Yes, it does state that at the top. There's no dispute here, however, that the plaintiff received this notice of intent.
That makes it kind of interesting, because it seems like there's at least arguably a procedural defect, and then arguably maybe a need, if there's any need at all, to have a hearing so as to avoid any due process notice concerns. And you have frozen again, if you can hear me, I hope. I don't know. Rita, do you have a way to get a hold of her?
I can have the clerk's office give him a call if you'd like. And if anything, we can have her.
She's back again. Hold on. Okay. You're back, counsel. You were frozen again.
Okay. I'm sorry.
I don't know what's happening, you know, where it is. I don't have the technological skills.
Okay.
But let me not interrupt you. Let me go back to the rest of your argument.
Sure.
Because apparently when we interrupt you, you get frozen when you respond. So we're gonna let you go.
I'm sorry, my
Okay.
people are getting the IT folks, so maybe they can figure out what's going on. But in the to continue, there's no dispute that the notice of intent to dismiss was received, that the plaintiffs responded to it. There is also no dispute that only one return of service was filed before the date that the court stated that the case would be dismissed without further notice unless good cause was shown 5 days before in writing. There was no hearing scheduled by the plaintiffs pursuant to that notice. The order of dismissal was entered on November 16th, 2 days after the dismissal date stated in the notice, and no activity occurred in the case again for the next 3 months. In February of this year, the plaintiffs at that time filed a motion to reopen the case or for case management conference. And that motion did not state any rule or legal authority and stated that the plaintiffs were unaware of the status of the case, whether it had been dismissed, and sought a status conference or to reopen the case if it had been closed. The underlying arguments that were stated in that motion were arguments challenging the dismissal as incorrect, that namely the amended complaint restarted a 120-day notice, and that the letter sent to the judge following receipt of the notice of intent was good cause to avoid dismissal. Following a 15-minute non-evidentiary hearing on that motion to reopen, the court entered an order granting the motion to reopen and vacating the order of dismissal, which stated that the defendants were served the day before the order of dismissal was entered, and also stated that the rule on the 100-day requirement to effect service is not intended to be a sanction. The court lacked authority to undo the final order. It was not free to change the outcome of it. And for that reason, the order that it entered should be reversed. As an initial matter, the order of dismissal that was entered was a dismissal of all claims against the only 2 defendants, and for that reason was a final order, even though it was a dismissal without prejudice. And it is well established that once the court enters a final order, that it loses jurisdiction over the case and cannot vacate, alter, modify the final order. And there are only 2 limited exceptions, which are Rule 1.530 and 1.540, which are the rules governing rehearing and relief from judgment, respectively.
Let me ask you a question dealing with another rule, which is 1.070. Because that rule says that, if service isn't made, the court may or shall direct that service be effected within a time period or dismiss the action. It then goes on with a motion for leave to amend. We know we don't have a motion for leave to amend here, but basically it says that if there's an amended complaint filed, the time period starts over. Again, shall begin upon the entry of an order granting leave to amend. But the law is also really clear that a party is entitled to amend without leave of court prior to, can you hear me? Because you are frozen against Ms. Nyberg. Ms. Nyberg?
Yes, yes, I
I'm
can hear
not
you.
sure. I'm not sure where you froze or if
Yes.
your audio was still going. But
Yes, I heard you.
What I was trying to go to is, if a party has an automatic unilateral right to amend the complaint, which they did here, why would the trial court not be able to say, okay, you didn't get service, there were lots of things going on, different problems going on, but you've amended the complaint, and I review this entire situation as one where I'm not going to dismiss it because the clock starts over. It's not exactly within the language of the rule, but I'm trying to juxtaposition to the rule the automatic right to amend that a party has. So tell me why that is an error by the trial court to not be able to do that.
Sure. So the language of the rule about motions for leave to amend and service of an amended complaint, that was added to the rule specifically to address a situation where new parties were proposed to be added by a proposed amended complaint attached to a motion for leave to amend. And the situation that led to the rule amendment was that some courts were saying that the 120-day period started to run on the date that the motion for leave to amend the complaint to add the new party was filed, even though the new party was just a proposed new party. The motion had not been granted. And the difficulty there is that when it's just a motion for leave to amend, the clerk will not issue process. So the unfairness of the situation led to parties having that 100-day period almost completely expire when due to the pendency of the motion for leave to amend and waiting for the order to be entered and such. That portion of the rule only adds, and you'll see the language is specific. It says it's amended complaints that add new parties. The beginning of the subparagraph J talks about it's the initial complaint and service against the defendant when it's first made a defendant in a complaint. So it is, and that language saying that that it's directed to the defendant for the first time was added at the same time that the amendment language was added to the rule. So it's made clear that it's really just directed to address squarely address the motions for leave to amend and new parties.
One other aspect about that rule that caught my attention, it says if service of the initial process and the initial pleading is not made. And here there was a contention in the motion or in the letter to the court that the clerk had not issued process. Was that fleshed out in any way?
In the hearings, no. On the record on the docket, it shows that no proposed summons was filed. There's no request for summons to be made. The clerk does not issue summons on its own initiative. There's a fee that needs to be paid and needs to be requested, the filing fee paid, and then the summons is issued. So there's no dispute that did not occur until the day that the court entered the notice of intent to dismiss. But going back to the underlying rule, that was not what the court could have done, what it had discretion to do. And there were different actions that the court could have taken under Rule 1.070 at the time, but those aren't things that it did. It did not grant an extension of time. It did not find good cause. What it did was it entered an order of dismissal. And so months later, in considering whether to reopen the case, whether to vacate that order, the court was operating could only exercise jurisdiction under Rule 1.540, relief from judgments. And that the case law is very clear that once the 15-day rehearing time period expired, the court lost any possible basis for jurisdiction to reconsider or revisit the merits of its underlying order. So at the time that the court entered that order and the time the motion was filed, the court was very limited to the grounds for relief that are articulated in the relief from judgment rule 1.540. And to invoke the court's jurisdiction under that rule, the plaintiffs were required to file a motion and establish mistake, accident, excusable neglect, that the order is void, one of the enumerated grounds in the rule. Here, the plaintiffs did not seek relief under the rule or based on any of the grounds that are articulated in the rule. The court's order granting their motion on its face does not vacate the judgment based on any of those grounds. And rather, the court stated, just that the service occurred one day earlier and that it wasn't meant to be a sanction. Those are revisiting the underlying decision, which was already made and could not be revisited at that time. Even if the grounds under the rule 1.540 were alleged by the plaintiffs, and even if the court had purported to rely on one of those grounds in its order, it's undisputed that no evidence was presented here, and that the law is clear that the party that is seeking relief from judgment has the burden to come forward with evidence to establish the existence of one of those enumerated grounds. And the mere arguments of counsel are always insufficient as a matter of law. Evidentiary showing is required. And the law is equally clear that the court lacked jurisdiction to vacate, amend, or modify the order based on any ground outside the scope of 1.540. So it was therefore an abuse of discretion for the court to reopen the case and to vacate it based on those grounds stated in the order, which are outside the scope of the relief from judgment rule. And even if the court's order could be read as being based on any ground enumerated in the rule, it was an abuse of discretion for it to grant the motion without an evidentiary hearing. And the arguments that the appellants make in support of the order reopening the case do largely go to the reasons that they believe it was error to dismiss the case in the first place. So they argue it was legal error to dismiss the case for failure to effect service under the standards of 1.070. For example, the 100 days being renewed by filing an amended complaint. They also argued that they had submitted a letter showing good cause. Again, those are things that went to the underlying merits of the court's decision under 1.070 and were not the issues before the court or within the scope of its jurisdiction to grant relief from judgment. The appellants also
You are at 17.
Okay. All right. Thank you.
That's up to you to keep going. That's not telling you to be quiet. That's letting you know it's your
Okay.
time.
Okay.
We go with
So-
whatever you want.
Sure. I will just briefly finish the thought. So the court, the other arguments are that there is a ministerial error, but there is no determination that there is a ministerial error. There's the order's clear as to the lack of any finding in that regard. And so based on the abuse of discretion and going outside of the rule granting relief from judgment, doing so without an evidentiary hearing, the appellants asked the court to reverse and remand with instructions to reinstate the order's dismissal, or alternatively, if the court determines that there was a facially sufficient basis for relief from judgment articulated in the motion, to reverse and remand for an evidentiary hearing on the matter. Thank you.
We will hear from the appellee at this time. You may proceed, counsel, although you are muted on my screen.
Thank you for the heads up on being muted, Your Honors.
It happens to me all the time.
My name is Crystal Sebago. It's a pleasure to be in front of the panel this afternoon. I represent the appellees in this case, and the court may be surprised to find there's a lot that I agree with about what Ms. Nyberger has argued. I've sat in on all of the meetings this morning on the docket, and I think I'm the only one who can say that there are some quite a few points of agreement that we have. I could regale the court with a timeline that's all set in our brief about when we filed the case. We received the court's notice of intent to dismiss in October. We immediately responded to the court and took appropriate actions to amend the complaint, issue summonses, apprise the court of our efforts, and requested a hearing. One of the things I will point out to the courts, and I did this in our answer brief as well, is that this notice of intent was extremely, I mean, it looks obvious what you're supposed to do, but it's kind of vague. And by the way, there is no dispute that I did receive this notice of intent. I want to make sure that record is clear. But it says we need to write to the judge of Section 7. I'm aware of Florida law on the requirements to serve process. I've been practicing a long time. And I know that courts like for their orders to be strictly followed. So in receiving this notice of intent, I forwarded a letter to the court advising the Honorable Judge Muscarella of our efforts and requesting a hearing time if she needed further clarification or found that our response wasn't good cause. Thereafter, we didn't really hear anything from the court, and I had checked the docket, just to make sure everything was on track. And on November 14th, there was a entry, and this is in the record, Your Honors, that the dismissal date was canceled by the court. And so I relied on that, seeing that. So I filed I got the summons issued, the clerk issued them, the defendants were timely, in our opinion, filed within 120 days of the amended complaint. And then, of course, I have the October 13th date on my calendar for 120 days to make sure everything is moving along and all the paperwork's in. And I look at the docket and realize that the defense hasn't responded to anything, filed any answers to discovery, what have you. And I start filing a flurry of motions. And at some point, Ms. Kilpatrick, defense counsel, it's undisputed, sent me an email saying, hey, this case was dismissed. And that was absolute news to me. So, and if the court looks at the dismissal order, my name is not on it. I don't know how they served it. I did see that they sent something to a defendant, but I don't know how the clerk of court served this. I received this from defense counsel. So I copied, I requested a hearing in front of the judge, or I emailed the JA and asked her if the case was open or closed. And she said, well, set a status conference, which is what I did. Out of an abundance of caution, not knowing what in the world is going on with this case, seeing that the case is noted as open on the docket, not having received a dismissal myself, and me trying to piece together everything that had occurred on the docket, which is kind of vague. I just got something filed as quickly as I could, just simply to find out if the case was open or closed. And out of an abundance of caution, saying, hey, we need to reopen this if it's been closed, like we don't know. At the hearing, not only was I confused about the procedural posture of this case and its present status, the court was, which I referenced in, I cited to in our answer brief, and so was defense counsel, who admitted on page, who admitted at the hearing if this case has been closed. So none of us knew, Your Honors, what is going on here. it was very vague, and it's on page 93, line 18, when defense counsel says if the case has been dismissed, and pardon me, appellant counsel says if the case has been dismissed. So the court didn't really give us an answer in the hearing. The record reflects we ran out of time in the hearing, and also just the confusing nature of everything. So the court asked us to submit memo style orders. Well, then this order from March, and that's on appeal before the court, followed. I do not in my opinion, I think the court made the right decision, but it's not supported by the facts necessary to support it. In a perfect world, had the court said, hey, the case was dismissed and it's dismissed, given us some sort of inclination, because if you go through and look at the docket, it's very difficult to discern. No matter what the appellant says now, everybody was confused at this hearing, and it's reflected in the transcript. I would have received some sort of clarification. Yes, it's been dismissed. Okay, then do what you need to do to get this, overturned. File an affidavit, file a motion, what have you. But as the court knows, because I've read practically every case from the second DCA involving this, you have to have very fact-specific motions for a 1.540 rule for relief of judgment. And if the case isn't closed, if it's dismissed as to one defendant only, if it's, it's showing open on the docket, you don't want to waste a court's time with things that are not accurate. And so really the reason why this 15-minute case management conference / motion to reopen case if necessary was filed was to just figure out what the heck is going on. And then this order followed, and I agree it's not supported by the appropriate findings of fact that the court needs to make if this court were reviewing this under a 1.540 standard. I attempted to make a tipsy coachman argument, but I know that that doesn't apply. So, what I believe the case law would support, I couldn't file anything else because this appeal was filed. And of course, the lower court loses jurisdiction. In a perfect world, would have found out the case was closed and filed the appropriate motion. Things moved too quickly, and there was no final determination as to whether the case was open or closed at the time of the hearing. I have ample evidence I could provide if necessary. I do think that the motion that I filed, as bare bones as it is, just to fire something off to figure out what in the world is going on, and also the hearing transcript itself does have a color of relief that I would be entitled to. We are still within a year from the date that this dismissal order was out. I do think if this were remanded, I would win on a 1.540 formal motion. But that opportunity just was not available due to the filing of the instant appeal. That's really all I have to say. And I thank the court for your time and would be happy to entertain any questions you have.
Counsel, I've got one question, which I thought I saw it in the appendix, and now I'm not finding it. You had said earlier that the trial court basically canceled the dismissal as to your case. I think that's the way you phrased it. Is that in the record before the
Yes, Your
dismissal?
Honor.
I thought there was something in there.
On page 6, and this is another cause for confusion, why we had to have the status conference. Page 6 on November 14th, there's a note that says canceled, CANCELED, dismissal date for lack of service.
Okay, so
Current
I'm
activity.
looking at a sheet that says events and orders of the court,
Yes, Your Honor. And
and
then
I'm on
you would
page
look,
6.
yes, Your Honor. And if you would look at the November 14th, 2023 entry by the court,
November
it says
14th.
canceled.
Got it. That's the one I had seen earlier. And that is November 14th. And when was the order of dismissal entered?
November 16th. which the record at the hearing reflects we did not receive. However, I have not filed an affidavit to that effect.
And then the indication next to that entry is Judicial Officer Patricia Ann Muscarella. I don't know if that indicates that she made that entry or if it's just listing that she is the assigned judge. Is there anything, and did the judge address that at the hearing? Because I don't recall if she did or did not.
I think I said Your Honor made that entry and she did not, and Her Honor did not dispute that.
Okay,
But I would have to go through and scan for that, Your Honor, to let you know for sure.
very good. Those were the only questions I had. Thank you.
Thank you, counsel. You have 2 1/4 minutes remaining for rebuttal. You may proceed.
Thank you, Judge. The only point that I would like to make is that the issue of lack of receipt of the order of dismissal was something that was noted in passing in the motion to reopen the case, but it was not an argument raised at the hearing, which I think is significant. The hearing was focused on a ministerial error that the plaintiffs believe existed because they believe that the merits of the order of dismissal were incorrect. They believe that the 120 days had restarted and that they had shown good cause by that letter. So the basis that is urged here as a basis of requiring remand for an evidentiary hearing was not something that was raised at the hearing as reflected in the transcript. So other than that, if there are no further questions, the appellants would ask the court to reverse and remand with instructions to vacate the order.
Okay. Well, thank you, counsel. Thank you both. Thank you for your candor to the court. We're glad we finally got the bugs out of the system too. Got to see everybody to the very end. And with that, we'll wish you all well and thank you for your presentation today. The proceeding is now in recess.
Thank you.